Sham marriage, fraud, marriage fraud. Is there any hope? In this video, I'll talk about limited possibility, form of relief, from removal based on marriage fraud. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy those type of content, go ahead and share, like, and don't forget to comment below. Let's get right into it. Is it possible? Can you get a relief based on marriage fraud? Before we get into it, let me just say one thing. If there's a person on this channel or somebody that you may know that is being tempted to engage in such criminal activities, please don't. It's not worth it. Just don't. If you've been tempted, if you just want to go ahead and do it, maybe somebody's telling you, just do it, I've done it, it was easy for me, just pay the money and just go ahead and do it, engage in such criminal activities, just don't do it, because there are a lot of consequences. And this is one of those offenses that's pretty much unwaivable, really. And in this video, I'll discuss the details. Let's get with the first consequence. What is the first consequence? The first consequence is inadmissibility. Remember, we have talked about grounds of inadmissibility before, and this, among other things, marriage fraud is a ground of inadmissibility, meaning that you will not be able to adjust status later on. Okay, just don't do it. If you have done it before and on your petition it says sham marriage or fraud marriage, we're going to discuss limited venues so that you can see if there is such relief available for a person who has been involved in such activities. Okay, first again, let me go back and define, because I forgot to define it. Let me go back and define what is sham marriage. Sham marriage is basically when somebody gets into the marriage with the intention of evading immigration laws. Basically get in the marriage not with the intention to stay, not for love, just to get there and get the green card. But remember that the intention that you have is to get a green card, but it is so difficult that if you are engaged in such activities, what is going to happen is when you go to the interview, they are going to separate you, put you guys in two separate homes. And if you don't know your partner in such higher level, in the level in which just like a spouse, spouses might know themselves. So if you don't know the person on that level, my friend, you will not make it to that interview. It's going to get denied. And if they go further on and investigate and find out that this was fraud, this is it. That's it. Finito. So just don't do it if you haven't done so. Just resist the temptation. Just resist. Don't do it. So that's it. That's it. That's what I wanted to say. And remember, with fraud, it's so specific that they have to investigate more in order for them to declare that this marriage was fraud. So because with fraud, you have to show with clear and convincing evidence. So that's why sometimes the decision comes and they just say marriage not entering good faith, which is better than if they say fraud. So if they say marriage not entering good faith, it simply means that you couldn't prove that the marriage was entering good faith, not lack of evidence, stuff like that. And you can go ahead and remarry and do something else. But when it's fraud, my friend, it becomes more than that. So that's what I'm saying. We talk about the first consequence, which is inadmissibility. Let's move on to the second consequence. What is the second? Second consequence is prohibition on subsequent petitions. Meaning what? Meaning that, let's say that the person was involved in sham marriages, and on the decision letter they said clearly that it is fraud, and what's gonna happen is later on in life, if the person meets the real person to marry, like now they're engaged in a real marriage for love with intention to stay, unfortunately, they will not be able to adjust status because Section 204C is attached to that petition. So clearly that section is prohibiting somebody who is involved in sham marriage fraud, to be able to petition later on and adjust their status later on, whether through family-based or employment. That's it. So let's move on to the third and last consequence. Last consequence is deportation. You can be subject to deportation if they figure out that it is fraud, that the marriage was fraud. You will be subject to deportation. The person will be subject to deportation. When I use the word you, I'm not just addressing to you, maybe somebody that you may know, etc., etc. So the person will be subject to deportation, and it could lead to a criminal penalty. Basically, the person can find themselves in prison for 5 years or 7 years. So this is a crime that is really punishable by prison. So just don't do it. That's it. Just don't do it. Resist the temptation. It is not worth it. Okay? And then now, what are the remedies for people who maybe by mistake, maybe by ignorance, or maybe willingly, really. So people who have been involved in such criminal activities, what is going to happen is they have limited venue for remedies. So the first thing they can apply for is waiver of inadmissibility. But this one is going to be really hard to convince the immigration officer or the judge. Basically, because you are the person who's in deportation, they only deal with the judge. So anyway, it's going to be difficult to convince them, because it says that if an alien is deemed inadmissible under Section 212A 6C for marriage fraud, he or she will likely be ineligible for Section 212I, the waiver, in applying for an immigrant visa or adjustment of status. Because why? Because in most cases, Section 204C will be attached and will render the waiver moot. Basically, when let me explain this one. Basically, it clearly means that, simply means that once you have been convicted or deny a petition based on marriage fraud, what's gonna happen is there is a prohibition. There is a Section 204C that it is attached to your subsequent petition, meaning that when you go ahead and marry another person, they bring that section back to that petition, and they will clearly say to you that 204C is attached. You cannot adjust status because you are prohibited from subsequent petition, either by employment or by family members petitioning for you. So, and then once you bring the waiver, then they say that waiver is moot because you don't have qualifying relative. Remember, when you go marry the second person, you will not be able to use that spouse as a qualifying relative in order for you to be able to use Section 212I, the waiver one. You will not be able to use that person unless you have children outside of that marriage, so that you can use those children as qualifying relatives for the purpose of the waiver. Remember, waivers are discretionary, and in the context of marriage fraud, the waiver become even more discretionary, because the way they will corner you around is by bringing Section 204C and talking about mootness. So basically saying that the issue has already been litigated, we cannot litigate this issue again. That's why it's not worth it. It is really not worth it. If somebody is being tempted or advised by friends, family members, just do it. You're only going to pay $3,000, or you're only going to pay $5,000, or even $1,000. Don't do it. It's not worth it, because later on in life, you might get real opportunity, maybe through employment, maybe through a real marriage, and you will not be able to adjust status. It is really difficult to adjust status with a fraud marriage under your belt. So that's what I'm saying. And then, what is the limited possibility for people who have, by mistakes, ignorance, or willingly done it? So what can they do? Basically, the only thing they can do is try to apply for that waiver. Remember that waiver will be very difficult because they use Section 204C and mootness in order to corner you around and in order to just deny it. People have tried it before. We have case law to demonstrate to you that people have tried that waiver before. It didn't work. But another thing you can do is cancellation of removal. And remember, cancellation of removal is limited. Basically, you must have been here for 10 years, no criminal record. But remember the context, then the fraud comes as a criminal record or a violation. And then extreme hardship, then you have to have qualifying relative. Some extent it might work, but remember, with cancellation removal, you are not really adjusting status. You might just get a permission to work, and in rare instances, you might get a travel document. So basically, parole with a permission to travel. So again, for those who have not done it, just don't do it. Not worth it. Okay. Cancellation of removal, waiver, those are things that you can do to remedy that problem. Another solution will be, let's say, for example, people who are applying on the T or U visa. Basically, they're victims of certain crimes, qualifying crimes. I've talked about T and U visa before, and lately I've gone deeper into the U visa. But let's say later on in life, the person who was involved in marriage fraud becomes a victim of a qualifying crime, and now they want a petition. Can they do that? Yes, they can do it, because the waiver that is attached to the T or the U visa, it's a different type of waiver, and it's might be much easier to adjust status under that T or U visa, because you gain more sympathy, because now you are a victim of the situation has changed, circumstances has changed. Of course, you did something wrong in the past, but now you're a victim of a qualifying crime, especially if it's a horrible thing that has happened to you. You gain more sympathy, and that way you will be able to adjust status. But not a lot of people fall into those T and U visa to be able to adjust status later on. So some people are stuck with just cancellation of removal and try to fight their way through a waiver so that they can adjust status. Another form of relief will be asylum. And again, asylum has its own options and requirements. If qualified, then you can apply for asylum, and then hope that it gets granted so you can adjust status later on through asylum. But remember, in conclusion, what I want to say is that for people who have not done so, don't do it. It's not worth it. It's not worth it at all. It is an offense that is almost unwaivable, pretty much impossible to waive. Very difficult to convince the immigration officer or the judge to waive that, so that you can adjust status later, either by employment or by marriage. Then you have limited option left, so don't do it. It's not worth it. For people who have done it by mistake, ignorance, or willingly, really. So what we have to do is try to find out whether those limited avenues for relief can apply to you. For consultation, please call 202-751-2180. Email on display. Just remember that consultation fees apply as usual. We will not talk to you until you sign the consultation agreement and you agree to pay the fee, and you actually pay the fees. So then we schedule you for a consultation. Okay? Bijoux.Ngwanda here, immigration lawyer in the DC metropolitan area. And this was U.S. Immigration. Until tomorrow. Bye.